Hi, it's Mike DelSignore, and in today's video, I want to talk about what happens if you're charged with OUI by the Sturbridge Police Department. So arrest by the Sturbridge Police Department might be the state police Sturbridge or local police Sturbridge. These cases all go to Dudley District Court. It's a court I've practiced in a lot over the years, and I can explain the process. So cases in Dudley has just two sessions, but they don't have a jury session. So if you want a jury trial, the case would go to East Brookfield for trial. Now, I've resolved many cases in Dudley. If you want a bench trial, and often the cases can be handled by the bench trial in Dudley, then the case would stay there. But before we get into sort of the mechanics of the court, the most important thing to understand when you're charged with an OUI is these are winnable cases. It's just a crime of opinion. So don't be quick to resolve the case. I was talking to a client today. She's on her second offense OUI, and I looked at her first offense, and I said to her, geez, you shouldn't have pled this case out. And the attorney she had was quick to see a breath test reading, and thought the breath test was going to come into evidence. The case was not winnable. Without the breath test, the case would have been a not guilty. The breath test likely would have been excluded, as there's problems with the machine now, but back, this was just a few years ago. There was a lot of problems, and I had clients from basically 2012 to all the way up until 2019. None of those clients had their breath test evidence come into evidence. So keep in mind the breath test, to get it into evidence, they have to show the machine's working properly. They have to show certified that you consented and that they complied with an observation period. So this isn't, breath test evidence doesn't come in every case. There's ways to challenge it and fight it depending on your medical condition. So that's mistake number one, assuming the case can't be won because there's a breathalyzer. Number two, you might hear about a continuance without a finding, and you might hear it's technically not a conviction, or you might hear the words dismissed in court. But a quaff is essentially the same thing for an OUI. So for many people, it doesn't really make sense to take a continuance without a finding. It's going to have the same long-term consequences as if the judge found you guilty. So there's not a huge benefit to resolving it. A lot of people think they want to get it over with, but you're not really getting it over with. The case is, you're still going to be on probation, have to do a program. So don't hear dismissal and quaff and assume that that means it didn't happen. It's not the same thing as dismissal, not guilty. It's basically terminology. It's basically you're admitting guilt, whether you take a quaff or whether you even were found guilty. So the other mistake I see people make is they read the report and they don't understand how, as a defense lawyer, I'll look at the report. So just yesterday, I had a client, I told him, "Oh, report's really good." He said, "Oh, what do you mean? I thought it was bad." Well, if you don't know what the police are trained to look for, you don't really, you can't read the report the same way I'm going to read it. And it's just the way I read the report, and the report has the same language in it. I'm more concerned with what's missing from the report than what they say in the report. So everything they say in the report is all the bad stuff. So they're going to say everything you did to support the arrest. What they don't say, but they will say on the witness stand, is everything you do right. So if they were to write a complete police report, they would, on the field sobriety test, like, for example, it's common for the police to say someone missed heel to toe, they stepped off the line. If they'll write a complete report, they'd say, well, he maintained balance in the instruction stance. That was inconsistent with my opinion that he was under the influence. He started on time. He followed instructions. That showed good mental ability. The person took the correct number of steps and didn't stop while walking. And then the officer would say, and I only saw the person step off the line 2 or 3 times, but the other 15 steps were online. So that would be kind of how the report was written if it was to include everything. But instead, the reports are written where the officer will say, stepped off line, unsteady on feet. That's actually a great report for a 9-step walk and turn, because that means you did about 7 things right. So that's kind of how I look at the report. There's other things that won't be in the report, such as how you got out of the car. They're looking to see if you lean on the car, use it for balance. So if there's nothing about that, if the report says, I asked the person to get out of the car, they walked over and did field sobriety tests, that's key evidence for us, because that means you didn't grab on the door jamb, you didn't lean on the car. The officer is taught to look for this in the training, and it's a sign that's inconsistent with somebody under the influence of alcohol. So gather up all those facts and show that you weren't impaired, show that this could very well be that maybe you're under the influence, but maybe you weren't. And that's all we need to get to, is that there's some doubt here, because that's what reasonable doubt means. That means that it could be one thing or it could be the other. We don't know.